6 days or 5 days. The swabs wouldn't last that long.
All right, the state arrested. Mr. Faust, I'm going to address you. You don't need to respond to the court. I'm going to address you, and then I'm going to take a break. And Mr. Cruz, you let me know when you're ready to proceed.
Yes, ma'am.
All right. Mr. Faust, the state has rested. And what that means now is this, that this is the opportunity, if you and counsel want to present evidence. The burden is not on the defense. It's always on the state. But most importantly, I want to speak to you about your right to remain silent. You have the absolute right to remain silent under the Constitution of this country and, of course, the Constitution of Georgia. And that means exactly what it sounds like, that no one can make you take the stand and testify against yourself. Even your lawyers. I always tell persons that I'm speaking to speak with their attorneys and to listen to their advice. But ultimately, at the end of the day, the decision as to whether to testify in your own defense is yours and yours alone. I want to make sure that's clear. But you have the absolute right to remain silent. I want to make sure you understand, Mr. Faust, that if you decide to take the stand, that you will be cross-examined by the state, and you need to understand that. But you have the absolute right to remain silent, and again, no one can force you in any way to take the stand and testify. Mr. Cruz, do you have any questions that you would like the court to ask your client at this point?
Not at this time, Your Honor.
Okay.
We'll talk.
I'm certainly going to give you time to talk. Take as much time as you need. Let me know when you're ready, and then we'll address any other matters.
Yes, ma'am.
All right, court is adjourned until that time. Thank you. You can just let us know, Mr. Cruz, by letting the bailiff know, and we'll come back upstairs.
Yes, ma'am.
All right, thank you.
We have a room to speak in. They typically just use this room down here. Can our team go to the room and talk with Mr. Faust?
Certainly happy to facilitate that. I'm going to leave that up to the Sheriff's Department. Yes, you know what? I think this would probably be best. I'll give you the courtroom.
Okay.
And I'm going to tell everybody who is in the courtroom to vacate the courtroom until we start court again. So I'll do one more time. As I said earlier, I hope you've had sufficient time to speak with your counsel. I want to make sure you understand that you have the absolute right to testify, but you also have the absolute right to remain silent. If you choose to remain silent, I will instruct the jury that they are not allowed in any way to use that against you or to hold that against you or to consider it in any way. All right, thank you. Mr. Cruz, anything you'd like to articulate to the court?
A couple of things. Before we get into the case, Sharon, I want to let you know that I just found out my wife is in the hospital, so we'll need to address that shortly. All right. But to take care of Mr. Faust's matter, I've advised Mr. Faust he doesn't need to testify in this case. Okay. So I'll stop there for now. All right. I also have a motion as well.
All right, go ahead with your motion.
Your Honor, we're going to move for a directed verdict in this case. The law provides that on a motion for directed verdict, the evidence must be construed in the light most favorable to the party against whom the motion is sought. So, as the Honorable Court is aware, the evidence has to be viewed in the light most favorable to the prosecution in this case. A directed verdict is authorized only when there is no conflict in evidence. So, as the Honorable Court is aware, if I present evidence of one thing and the state presents evidence of one thing to that count, there cannot be a directed verdict. It has to go to the jury. And that's as to any material issue and the evidence introduced with all reasonable deductions therefrom demand a particular verdict. So the counts that we were asked for a directed verdict to, first we'll start with burglary, Your Honor. In this case, and I believe that is count, burglary is count 6, Your Honor. And in the indictment, Mr. Faust is charged for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did unlawfully and without authority enter into and remain in the dwelling house of Tara Baker with the intent to commit a felony therein, to wit, aggravated sodomy and rape in violation of OCGA 16-7-1. The evidence in this case presented in regards to the burglary count, as the Honorable Court is aware, none of the state's witnesses have disputed that outside of Mr. Faust's DNA being in Ms. Baker's body, there was no evidence connecting Mr. Faust with the home. In fact, the state mentioned in opening that they can't present evidence of how Mr. Faust got into the home. So in regards to count 6, our position is the evidence does not conflict. The evidence is actually favorable to the defense, even if viewed in the light most favorable to the state, because there is no evidence presented that puts Mr. Faust in the home or shows that Mr. Faust was in the home at any time. In regards to aggravated sodomy, Your Honor, all the testimony in this, and let me make this specific, the aggravated sodomy count involving the anus of Ms. Baker, which is count 10. So far we've done count 6. Next is count 10. All the evidence in this case, in regards to aggravated sodomy, it is undisputed that Chris Melton's DNA profile is the only identifiable DNA profile in Ms. Baker's anus. Dr. Falzone testified that based on her injuries, they were consistent with sexual assault. Ms. Hinkle testified that the anal DNA only lasts for according to the articles, 2 days to 3 days at most. The state asked her a question, their very last question to Ms. Hinkle. They said, could the timer reset? As the Honorable Court is aware, viewed in a light most favorable to the state, we have to accept that Mr. Melton last saw Ms. Baker on Sunday, last had sexual intercourse on Sunday. If we give Mr. Melton the 3-day window, that puts us at Wednesday with his DNA in Ms. Baker's anus. However, the DNA wouldn't still be present because the state's allegation is that Mr. Faust committed these acts on Friday. So there is no evidence that the state has presented or that could be construed even when construed in the best light, even when construed favorable to the state, there's no evidence that would support or that conflicts in regards to Mr. Faust being in Ms. Baker's anus. So we ask for a directed verdict on that count. In regards to count 11, arson in the first degree, we're also requesting a directed verdict. Again, it flows, the state has presented no evidence whatsoever that Mr. Faust was in the home. The closest the state came to that is, if we view the evidence in the light most favorable to the state, is that African Americans were seen walking around the Deer Park neighborhood on the day of Ms. Baker's death. But the state has presented no evidence. There's no conflict in the evidence. There's absolutely no evidence supporting that Mr. Faust started a fire in Ms. Baker's home. And again, what we rely on is the evidence presented through the reports as well as the testimony that law enforcement officers did not find anything connecting Mr. Faust with the home. The only place Mr. Faust's DNA was located, again, Your Honor, was Ms. Baker's body. That same reasoning flows to count 12, possession of a knife during the commission of a felony. There's been no evidence presented that Mr. Faust had a knife or possessed a knife in this case. As well as count 9, count 8. So count 9, not count 8 or count 7. Count 6, we've discussed. And counts 1 through 5, which are malice murder, felony murder, felony murder, felony murder, felony murder. And just for purposes of the record, I'll address count 7 and 8. The evidence viewed in the light most favorable to the state, Mr. Faust is, and obviously we disagree with it, but we have to view it in the light most favorable to the state. DNA is in Ms. Baker's mouth and in Ms. Baker's vagina. Again, we disagree with that, but I understand the standard. We have to view it in the light most favorable to them. And the state's position is the reason it's there is because of rape and sodomy. There is a conflict in evidence there, so we're not requesting a directed verdict on those 2 counts.
Which 2 counts?
That is 7 and 8. 7 is the aggravated sodomy involving the mouth. 8 is the rape. And of course, Your Honor, our position is there was no rape that took place in this case, but I have
He's
to,
not asking for a directed verdict on
based on the law and viewing the evidence in the light most favorable to the state. But in regards to the murder counts, again, there's been no evidence presented by the state that Mr. Faust was responsible for Ms. Baker's murder, outside of just his DNA being present. And as the Honorable Court is aware, when it comes to murder, malice murder, they specifically state, on or about the 19th day of January 2001, Mr. Faust did unlawfully and with malice aforethought caused the death of Tara Baker, a human being, by strangling her with a cord and stabbing her. The only evidence in this case regarding forensic material related to the murder weapon, which is the cord, is that Mr. Melton's trace evidence was found on the charger block that was next to Ms. Baker's head that was connected to the cord used to strangle her. In regards to felony murder, burglary well, it should be burglary in a dwelling. Here it says burglary to a dwelling. Again, there's no evidence that a burglary occurred. The state admitted in their opening that they can't present evidence of how he got into the home. In regards to count 3, felony murder, aggravated sodomy, again, the basis of that felony murder is the strangulation, and I've already provided the Honorable Court the facts and evidence that came out in this case in regards to the strangulation in count 3. And count 4, felony murder as related to rape. The felony murder piece of it, again, there's no evidence of murder. And I emphasize, I know the court is aware, we disagree that a rape occurred. We disagree that that aggravated sodomy occurred. But understanding the law, we understand we have to accept that evidence and say it's favorable to the state's position. But in regards to the murder piece, there is no conflicting evidence on the murder piece. In fact, there has been no evidence presented by the state that Mr. Faust committed this murder, again, but solely that his DNA was present. So we would ask the Honorable Court to grant our motion for directed verdict on all counts, excluding count 7 and 8. We believe those matters are appropriate for the jury based on the conflicting evidence.
Thank you, sir. State care to respond.
Yes, Your Honor. I mean, I'll be brief. The court has sat on the trial of the case. You've heard all of the evidence, but certainly not only has the state carried its burden to provide evidence sufficient to get this matter to a jury, but the state's carried its burden of proving guilt beyond a reasonable doubt that Mr. Faust committed all of the crimes that are named in this indictment. I'm going to start at the top and work my way down, but in some ways, the evidence of Mr. Faust's guilt applies to each of these offenses. So I think that the evidence as shown at trial shows that an individual matching Mr. Faust's description was seen in the area of 160 Fawn Drive and in fact disappeared.
Wait a second. Not as bad as earlier today. Go ahead.
That was much faster than earlier today, but there was an individual matching Mr. Faust's description that arrived in or was walking in the immediate area of 160 Fawn Drive and then was seen to disappear in such a manner that that individual's only route of travel would have been between the homes immediately around 160 Fawn Drive. Further, there is obviously evidence that a murder was committed. There is also obviously evidence that a rape was committed, as well as aggravated sodomy, both orally and anally, is evidenced by Dr. Falzon's testimony about the forceful nature of both the vaginal sex and the anal sex, as well as evidence giving proving Mr. Faust's guilt beyond a reasonable doubt, much beyond the necessary standard for a directed verdict, especially when viewed in the light most favorable to the state. There are only 2 DNA profiles found within the home in Miss Baker's body. One of them is from her boyfriend. who had been in a loving relationship with Miss Baker and whose DNA was found within normal detection window, as testified to by the GBI witness in Miss Baker's vagina, and then explained as far as the presence in the anal swabbing at a much reduced match or frequency rate due to either drainage or transfer from the period of time in which Mr. Faust raped Miss Baker, orally sodomized her, anally sodomized her, and then murdered her by stabbing her and strangling her with a ligature, Your Honor. And so when we're talking about directed verdict, the manner in which the court views the evidence, as well as considering the significant evidence in this particular case, the state's met its burden as it relates to counts 1, 2, 3, 4, 5, 6. The defense is not moving for a directed verdict on counts 7 and 8. If they were, the state would have met its burden there. As to count 9, the state has met its burden. Count 10 and 11 as well, and count 12, obviously the knife was possessed during a commission of a felony as evidenced by the fact that Miss Baker's blood is on the knife itself, and it was a major contributor or the cause of death, along with the ligature strangulation of Miss Baker. And Detective Leadall testified as to the length of the knife being sufficient, being greater than 3 inches in order to satisfy the requirements of the statute, and as well as the arson being committed by the individual who had raped and sodomized and murdered Miss Baker, which would be Mr. Faust, as shown by the evidence in this case. I'm not going to go through a further recitation of the evidence because I know the court has sat in the trial of the case, but certainly the state has presented more than sufficient evidence both to survive a directed verdict and convict Mr. Faust as to all of those counts.
All right, thank you. Anything further? This is your motion. All right, thank you, sir. All right, so I know all counsel is aware of what this moment means and what the court's responsibility is, but I'm going to articulate it anyway. This is a moment where the court has to consider this statute, OCGA 17-9-1, when direction of verdict of acquittal authorized. When there is no conflict in the evidence, and the evidence introduced with all reasonable deductions and inferences therefrom shall demand a verdict of acquittal or not guilty as to the entire offense or to some particular count or offense. The court may direct the verdict of acquittal to which the defendant is entitled under the evidence and may allow the trial to proceed only as to the counts or offenses remaining, if any. That's the law. That's what, Mr. Cruz, you have asked the court to grant under 17-9-1. And at this stage of the game, the court is not making any comment on the evidence. I want to make that clear. But what I am going to comment on is whether there is a conflict. That is what I have to find out. And if the court finds there is a conflict, the court has to deny defense's motion. I mean, that's just where we are. And so I want to just lay that out there. This court is not making a comment on the evidence, on the strength of the evidence, on the credibility of the evidence, on the lack of credibility of the evidence, the believability or not believability of the evidence. This is just a moment for the court to talk about whether there is a conflict. Both parties have articulated many times throughout the last 2.5 weeks the indisputable comment that this is a cold case. And in so articulating from both parties that this is a cold case, the parties have described in their ways why the evidence is or is not what it is. And a cold case, particularly one like this, is based on circumstantial evidence. And therein defines, in many respects, what a cold case is. And when the court charges the jury with the law that they must apply, one of the charges relates to circumstantial evidence. And juries are authorized to consider circumstantial evidence in making their decision. They don't have to, but they are authorized to do so. And they can give it whatever weight they care to. The court also charges the jury about circumstantial evidence, and in doing so also says that circumstantial evidence and direct evidence have the same weight, if any, and that one is not greater than the other. And any weight that is given to evidence is solely on the jury's shoulders. They get to decide whether they believe or they do not believe circumstantial evidence, whether they believe or they do not believe direct evidence. And that's the law that the courts give to every jury. That's your basic, I mean, obviously I'm paraphrasing. I'm not going to go back and read the whole charge to everyone. And I know counsel understands this, but I want to remind counsel that that's what the law is. And so based on all of that, and based on the law 1791 that says when there is no conflict in the evidence, I'm going to deny your motion, Mr. Cruz, for those reasons. Yes, ma'am. This is a circumstantial case, and the argument that you have made relates to evidence that is direct evidence. This is a case that is not really direct evidence, although you all can argue however you choose to about what the evidence actually is. But this is a case about circumstantial evidence, and the evidence that has been presented, therein lies the conflict. Both parties have had the opportunity to direct and cross-examine, and the evidence that has been presented to the state is the epitome of conflict. And so for those reasons, I'm going to deny your motion, Mr. Cruz, because it is the law. All right. We've gone through that. Let me have counsel at the bench, and let's talk about some scheduling matters. You all may be seated. Ladies and gentlemen, I'm going to release you for today. It's 4:20, and we're not going to start tomorrow until noon. It is possible that we actually may have all of tomorrow off. It's just going to depend on some circumstances. So if that is actually the case, you're going to get a call from the clerk's office, and they will tell you as soon as they know whether tomorrow is a kind of a free day for you. In the meantime, I want you to expect to be here at noon tomorrow. When I release you, of course, the same prohibitions apply we've been talking about for 2.5 weeks. I know you've been paying attention to that. Don't discuss the case with anyone. Don't do any research. Do not go to any of the locations that you may have heard about. Certainly try to avoid all social media that may have anything to do with this case whatsoever. Other than that, thank you for your patience today. I'm going to release all of you, and we will hopefully see you at noon tomorrow, but make sure that you pay attention to your telephone just in case. Thank you.